I'm Todd Masuda. I'm an employment lawyer in Cleveland, Ohio. I want to talk today about the FFCRA, the Federal Paid Sick Leave Act. Employers received a poster from the Department of Labor last week, and they were told to post this paid sick leave poster that sketches out certain rights. And I think it's caused a lot of confusion among people who are figuring out how to comply. So I hope this video will be helpful as we walk through some of the, just kind of break out the Paid Sick Leave Act. We're going to talk about what it is. We're going to talk about employers that it applies to. I'm going to break out the leave rights, which is basically talking through the poster, and so that you can figure out how to apply the poster. Then we'll bring up some unanswered questions, and then we'll address the question of perhaps leave abuse, something that might be leave abuse. All right, so first, the FFCRA is a federal paid sick leave act. It gives limited paid sick leave rights to employees for certain reasons. It takes effect on April 1st, and the leave rights are in place through December 31st. It's federal law, so it's being administered by the Department of Labor and the IRS. It does not have anything to do with the Ohio stay-at-home order. It does not have any element of essential business or operation like the stay-at-home order does. It's just a separate, limited paid sick leave right. All of the payments that an employer makes under this law are going to be offset again as a payroll tax credit each quarter. So if you pay out $5,000 of paid sick leave during a quarter and you owe $8,000 of payroll tax at the end of that quarter, you'll be able to take a dollar for dollar credit. If you have more paid sick leave than you have tax obligation, the overage will be treated as a refundable overpayment, as a tax overpayment subject to refund. All right. So that's the general gist of how it works. Who are the employers that this law applies to? The statute says it applies to private employers. We're talking about private employers here who have fewer than 500 employees. It allows employers of healthcare providers and first responders to exempt those employees from the paid sick leave right. So if you employ healthcare providers or first responders, that's an option you have. And there is also a provision in the law that says that will allow some employers who have fewer than 50 employees and whose business will be jeopardized by giving this right to opt out of to elect out of the law. But that does not, we don't have that guidance yet. And so I think employers who have under 50 employees should assume that they'll still be subject to this law. Okay, so now let's walk through the poster. Let's walk through the reasons who gets rights and why, and what those rights are. All right, so the FFCRA is made of two different paid leave rights. One is a new idea called paid sick leave. It's a Paid Sick Leave Act. And the other is an enhanced FMLA. I don't know why it's under the FMLA, but it's different from the FMLA, but there it is. So there are two different rights. The first, the Paid Sick Leave Act, is going to apply to all your employees. Pretty much everybody is going to have rights under Paid Sick Leave Act. Under the enhanced FMLA, there's an extended right to leave, but it's only going to apply to a much narrower subsection of employees for a much narrower reason. All right, So on your poster, you'll see that there are 6 reasons for leave. Now, under the Paid Sick Leave Act, your employees will be able to take leave for any of these rights, okay? So the first one is employees who are subject to a government order related to COVID-19. The second one is for employees who've been asked by a healthcare provider to self-quarantine or self-isolate based on COVID-19. And the third one is for employees who are experiencing COVID-19 symptoms and are seeking a medical diagnosis. All right, let's take, what are their rights? They have the most rights. They are entitled to 80 hours of sick pay for a full-time employee. It's prorated for part-time employees. At 100% of their pay, capped at $511 per day or $5,110 in the aggregate per employee. That's for reasons 1, 2, and 3 under the Paid Sick Leave Act. All right. So for categories 4 and 5, it's a different right. So category 4 is an employee who's caring for an individual who is subject to needs care subject to an order, or is self-quarantined at the advice of a healthcare professional. This is not just for a family member, this is for anyone, an individual, caring for an individual. And the 5th one is to care for the employee's child who is at home based on a school or daycare closing because of COVID-19. There's a 6th reason, which has to do with health and human services orders. There's nothing in that category yet, so let's disregard it for now. But for these reasons, the employee has, again, 80 hours of leave for full-time employee, but at 2/3 pay, capped at $200 per day and $2,000 in the aggregate. So when an employee comes to you and says, I need paid sick leave, you want to record the amount of leave that they actually take based on these categories. That way you'll know how much leave they get and how much your reimbursement will be based on these categories. So it's important to keep a record there. Another nuance here is that if an employee is caring for a family member, for instance, who has a fever, I think the guidance will be that employee, and so that will be number 4. Let's say you have someone in your house who has a fever and you're staying home caring for that person. Does that employee get 2/3 pay? I think that the guidance will be from a healthcare provider that employee has been exposed to the virus and is going to have to self-quarantine on the advice of a provider, so that employee will be entitled to 100% sick pay. All right, so employees are going to be using this leave because people are going to be getting sick. After that leave is exhausted, there's this second leave, which is the enhanced FMLA leave. The FMLA leave is, first of all, 10 days unpaid. And the way this works is the enhanced FMLA doesn't really apply while the paid sick leave applies. But after that, a certain subset of employees who fall in category number 5, taking care of the employee's son or daughter due to a school or daycare closing, will be entitled to additional 2/3 leave. Now, let me talk about how the employee category narrows. So, under the Paid Sick Leave Act, all employees are going to have rights. Under the enhanced FMLA, it will be employees who have worked for you for 30 days or more, and who have to, in caring for their son or daughter, they prevents them from working or from teleworking. So an employee who says, I need to care for my child, but who's still able to telework will not be eligible for this benefit. The benefit is still 2/3 pay, but it has a different aggregate cap. It's still capped at $200 per day, but the aggregate cap for this type of leave, enhanced FMLA, is $10,000. All right, now let's talk about some of the things that are still up in the air. It's a very new law, and we don't have all of the practical guidance we need from the DOL and the IRS. I already mentioned that we don't know how it will apply, or we don't know which employers who have fewer than 50 employees will be exempt from this law. We don't know quite how to document the leave here. You're going to need to apply for a tax credit later, and you're going to have to apply in these categories. So I think that employers do have to keep specific records of the amounts, leave taken and amounts paid under this law. We don't know how the withholding is going to be treated. We don't know what the tax treatment of these payments are. The statute says they're not regular wages, but beyond that we don't have guidance. So I think we can assume that we should just pay regular payroll, and as we have other guidance, we'll see what happens on the tax credit side. The enhanced FMLA is not really like FMLA, and one of the questions many people have is whether you can take intermittent leave for this child care. Although the enhanced FMLA statute states that leave is taken per day, the DOL has issued some guidance that says it can be taken intermittently for teleworking, as long as the employer and employee agree and work it out. And they encourage you to be flexible and accommodate this type of leave, the child care leave for teleworkers. The other thing is that employers are concerned about, I think many employers are initially concerned about paid sick leave abuse. They're concerned that employees will take it when they don't need it. Normally, I think that is a big concern, but I think that there are mitigations here. And the first is that during the coronavirus crisis, we want to make it easy for employees to stay home and minimize the spread of the virus, especially in these early days when the cases are ramping up. The second is that this is a limited paid sick leave right, and I think we can expect many people to need a lot of sick leave, and this may not cover it. I think that the message is we're going to need this sick leave sooner or later, so don't spend it before you need it. And the other two things are, it's a limited right. It's only for these categories, and also employers are going to be able to offset the cost of this against the payroll taxes that they would have otherwise paid. So I hope that softens the concern about paid leave abuse. Some employees will definitely be taking it without needing it, but I hope that we can have a lenient sick leave policy during these uncertain times.